Okay, it's 9 o'clock, and I know there's the time we've chosen and time of year we've chosen isn't that convenient, but we wanted to capture this content and get it up onto the LinkedIn profile. It's been a long time coming. So Helaine, let me welcome everybody today, and let me introduce myself, Andrew Cox. I'm the newly minted president of the Active Cyber Defence Alliance, which is just incorporated as an association in Australia, not for profit. We've been operating for several years, though, as an unincorporated association. And so we're looking forward to a new phase of our life and contributing to Australia's active defence. So let me introduce to our guests today, first of all, Helaine Leggat from ICTLC. Why don't you introduce yourself, Helaine?
Thank you, Andrew. Yes, well, firstly, as Andrew said, I'm with ICTLC, which is an international law firm, and I run the Australia office as managing partner. I have been involved in this field for some 20 years, and I'm really pleased that people are beginning to pay attention to this need to sort of harden your defences in order to meet your obligations as directors. And it's wonderful to have Gabby from MITRE join us on this.
So Helaine is really going to be the primary presenter today. I'll be acting as the interlocutor and trying to ask her some jagging questions to get the best out of it. But Gabby I'll let Gabby introduce herself, and then I'll explain how we're going to ask her to participate.
Yeah, thanks, Andrew. So hi, everyone. I'm Gabby Raymond. I am the capability area lead for cyber deception and adversary engagement at MITRE. MITRE is a US company. We own and operate a set of federally funded research and development centers. So I work closely with the US government and have been interfacing with our Australian counterparts to really talk about the opportunity space of cyber deception and adversary engagement. So very excited to be here today.
We recently were at the ACER conference in Melbourne in October together with Maretta Morowitz and a number of other people from MITRE and the MITRE Engage team, particularly speaking in several joint sessions. So it was a lot of interest gained too, I should say. So it was a great conference for us. So look, at this point now, I'm going to start sharing my screen, and we're going to dive into the content, which is really about how the law of self-defense plays in the cyber realm. And obviously, I didn't choose the most gripping topic. It didn't grab people's minds the way it should do, because this is a fascinating and absolutely compelling topic. And I believe that the content here is going to be really worthwhile. So just give me a second to fiddle with the technology. Something popping up. There we are. And so we've got the screen. So this is the introduction. Let me just jump on. First of all, let me just say this is all of our content is provided under Creative Commons, and we will put this material up. The slide pack is available if you'd like to reach out to me afterwards. And you can reach out to us at the Active Cyber Defence Alliance, ACDA.group. Let me talk just briefly about who ACDA is, and then we're going to move on. We always give credit to retired Major General Marcus Thompson, former head of information warfare in Australia, who never spoke publicly that I heard without talking about his 4 pillars of cyber defense. Self-defense, which is not having dumb passwords and clicking on stupid links, and not taking selfies in front of the battle map when you're on maneuvers and posting it on Facebook, as somebody once did, apparently. Passive defense, which is what we call cybersecurity. Well, really, these two things together, self-defense and passive defense, makes up cybersecurity. It's the passive postures, how to keep them out, how to keep the enemy out, how to build walls, how to virus filters, firewalls, passive scanning devices, and all the policies and so on that we put around the Essential 8, the NIST standards, the ISO standards. And then there's, on the far right, in bright glaring red, is offensive activity, which is the exclusive domain of our security agencies, and these offensive countermeasures are only allowed to be used by those authorized to do so under specific circumstances. But in between these, there's a gray area, which is active cyber defense. Marcus always defined it as intelligence, deception, and active threat hunting. I've added adversary engagement. Actually, sometimes we use the word lawful countermeasures, but I think maybe adversary engagement is a better way of putting it. And that's with a tip of the hat to MITRE Engage, because that's their language. And I think it's very good language. The conventional posture of cyber defense is very reactive. We're like a blind boxer in a boxing ring, with earplugs and completely blindfolded, so we can't see or hear what's going on, and we have to wait till the punch lands on us, and then we try and react. And that is always going to result in the sighted participant winning. Even if you're the best boxer in the world and you can land the occasional lucky punch, you're never really going to consistently win against an adversary that can see when you're blind, because you never have the initiative. And adversary engagement is actually about taking and holding the initiative, rather than allowing our adversaries to hold the initiative as we do at the moment. So I'm not going to enlarge on that now. I'm going to dive into the content of the presentation. And this is our agenda. We're going to talk first of all about what the law of self-defense is and how that applies in the cyber realm. We're going to talk specifically about directors' responsibilities and how this law affects them and their obligations as directors. And then we're going to talk more practically about how the law applies and talk about the way that you might do scenario planning so that you're preparing for the future of your business. And broadly, Helaine is going to put forward her informed view as a lawyer as to how the law applies and how these things work and the implications of them. And then I'm going to get Gabby to speak from an operational perspective as somebody that actually does work in incident response with the MITRE organization and explicitly in using these kinds of tools and techniques in those engagements, to talk to the extent that she can, appropriately speak about how this really works out and what the dilemmas are and what the solutions are and how these thoughts and concepts might assist in our defense. So Helaine, let's just talk about this question of self-defense and talk about how it really applies from the point of view of when am I criminally responsible for an action that I take?
Thank you, Andrew. I think we should begin just with a little context and a broader look at things. Briefly, I mean, human societies have dealt with legal issues for thousands of years. And the problem here is that generally we exclude all of the learnings from all of those thousands of years from the cyber realm. And for nearly 20 years, I've been arguing that we shouldn't do that. If you look at criminal behavior, and in Australia at our Criminal Code Act, there are circumstances in which if you do something or if you don't do something that causes harm, you can be criminally liable. But the Act itself actually recognizes specifically circumstances that involve external factors. And under certain circumstances, if you respond in a way where you might cause damage or harm, you will not be held criminally responsible. And this is what I want to look at. So we've sort of focused on self-defense here, but there are actually 4 very clear circumstances where the fact that you will not be criminally liable, even if you do cause damage or harm, come into play. The first one is where there is an intervening circumstance or event. The second one is duress. Then you get a sudden and extraordinary event that is happening, that's an emergency, or you get the actual factors that rely on self-defense. So if we look at self-defense, and we can discuss all of these because they're quite similar in a way, but they actually allow you to take action that might result in harm. And briefly speaking, I think we're getting to a stage now with the level of crime that we've got where there is more and more requirement on an individual or director or responsible party to behave rather than to do nothing. You can't, for example, sit and watch your data fly out the door. But if we look as a starting point at self-defense, it very clearly says a person who carries out conduct in self-defense, if they believe that that conduct is necessary, is not criminally responsible. And they can defend themselves or other people, property, from unlawful appropriation, destruction, damage, and interference. They can prevent criminal trespass, and they can remove somebody that's already in your buildings or on your network because they're criminally there. So there are a number of elements, but essentially, so long as you believe it is necessary, you can take those actions. And if there is some harm as a result, you won't be responsible. That said, it is qualified by the fact that you can't be so extreme in your behavior that you will cause death or serious damage to somebody. So we'll look at how this plays out when we look at the scenarios at the end, but that's the broad framing of what we're dealing with.
Thanks, Helaine. Gabby, I remember in one of the presentations you gave at the ASA Cyber Conference in October, you made a comment about how you need rules. You're responding to somebody saying, "Well, you need clear rules of engagement, so you're allowed what to do." But you also commented on sometimes you need a bit more freedom because you can't always predict how events are going to unfold, and so you need some discretion to act in new circumstances as they unfold. Is that comment relevant to what Helaine is discussing here?
Yeah, absolutely. So we always talk about how planning is a really important part, and I've looked ahead at these slides, and that will come up in a little bit too, the aspect of planning here. But for us, and buying down the risk equation for our organization, we always need to have our rules of engagement. At what point are we going to escalate when something triggers, something that we may or may not expect to see from the adversary? So, at what point do we want to decide to pivot away from watching and learning into doing incident response and removing the adversary from our network? So whether this is from the deception on production space where we've placed decoy systems and artifacts, or if it's something where we've self-infected with a piece of malware, having an understanding of what the organization's risk tolerance is and how the team is going to respond based off of information coming in is great. And like you said, Andrew, it's really fantastic when we've done like all of the thinking that we can and have outlined all of the possible opportunities that we could see needing to do that escalation. But that doesn't necessarily mean that what happens in the real world is reflective of all the planning that we can do. And so there is a level of adaptability and flexibility that a team needs to have. And I think that the biggest part of that is understanding what are your guide rails, and at what point do you need to call in more people to get more eyes and have a better judgment given the larger picture.
But not to gloss over this, when you talk about self-infected malware, what you're saying is that you put code in your network, which if somebody illicitly picked it up, could harm them. Is that what I'm hearing?
So we traditionally look at an isolated part of a network where we self-infect in an isolated part of a network. And so of course that also needs to go through the same sort of risk evaluation, because we've had issues before where if we see an adversary using MITRE as a hopping off point, then that's not a great opportunity for MITRE. We always worry about like, what is the Washington Post, or apologies, I can't call a Australian newspaper to the top of my mind, but we always worry about like what are the optics, what are the perspectives, and if an adversary is using our network as a hopping off point to attack another network, that clearly is something that we want to shut down immediately. So yeah, I hope that draws some good distinction.
So thank you. Helaine, are we ready to move on to this next slide?
Yes, so let me make a connection, because I'm speaking theoretically about the law at the moment, but to bring this closer to what Gabby's talking about is it comes together when you say you need to run scenarios, knowing what your goals are, knowing what's involved, knowing when you're going to stop doing what you're doing or call in help is absolutely critical.
Which is what we'll cover a little later in the presentation. Yeah.
I beg your pardon?
Which is what we'll cover a little later in the presentation. So directors' responsibilities, Helaine, and we had a very interesting panel with Michelle Price and Maretta Morovitz on the main stage at CyberCon, where this topic really did come up. And Michelle made some very strong statements on that topic. What are a director's obligations in this situation where somebody is doing damage in their network and they have knowledge of it? What are their responsibilities there?
Well, the first thing is that they are responsible for doing the very best they can for the company and protecting the company and the interests of the company and the shareholders and stakeholders. So if you consider a sample, again, an example, rather that there is some attack and they do nothing, that is not helpful. In law, an act is the same as a failure to act and omission to act. And what is interesting here, we've had our first case where we had, it was ASIC versus RI advice, and a fine of $750,000 was issued because the company didn't have sufficient cybersecurity in place. So we're only just beginning to get into cases where we are seeing a possible result or implications for directors who fail to do something. But that's it. They have to do something. They can no longer sit back and say, well, doesn't matter. And I think both the Optus breach and the Medibank breach have very much brought this into focus now, to the extent that on the 28th, so literally a couple of days ago, there were amendments to the Privacy Act here, over a number of reasons, increasing the fines to $50 million from just over $2 million. So we're seeing action. People need to take it seriously. The other point I want to make about this is the issue of how standards apply. In law, if a certain behavior is expected under certain circumstances and a director fails to meet that level of behavior, the reasonable man test, there are implications for that failure. And the higher the bar is in terms of what's expected for securing your environment from attack, the more you will need to behave in what is regarded as a standard of reasonable behavior. And that is changing. The bar is changing. It's going up.
So your third point here, directors have an obligation to consider lawful cyber defense countermeasures. I mean, that goes to the topic that we just brushed over there on terms of self-infection with malware. And I know that we'll dive into this in a bit more detail and talk about the nuances. But the reality is, if you're being attacked by a botnet, or there's combined activities that might extend outside of your network, and you have awareness of it, in principle, based on how I understood your explanation of self-defense, criminal trespass, and private property law, if I believe that I'm in danger, I can take reasonable proportional acts to defend myself. And I know there's lots of caveats about this because there might be an innocent third party's machine in the way. But that implies then that directors have an obligation to consider these more forward-leaning approaches, adversarial engagement approaches. And yet, when I'm in meetings with CISOs and senior people in the public and private sector, there's a great reticence and a fear of risk and almost a paralysis to act because they're just of the fear of unforeseen consequences. How does that play out in terms of a director's duty?
Well, the first thing is that they must know what their rights and obligations are. And as a director, you have a right to get information, to be informed, to rely on other people. So that's the starting point. There are many directors who don't have a cyber background, and they can rely on help. They need to educate themselves, and they need to realize that things are changing. That bar of responsibility, as I said just now, has very much changed. Something else that is relevant is that they need to consider the issue of unauthorized access. That's important, and it came up when Gabby was talking just now. There is a place where you might have decoys and malware within a segmented area of your network, and that's not an issue because it's your environment and you can protect it. The issue is, when do you go into someone else's space? When do you cross the border of authorized access? And then it becomes critical, because unauthorized access is de facto a crime. And this is what the directors need to understand. When is it absolutely okay? When is it gray? And when it is an absolute no-no? But nevertheless, these circumstances that I'm describing allow you to do certain things. So you might be able, in running these scenarios as directors, to go into areas that are basically no-go zones because you don't have the right to go there, to undertake certain behaviors. So for example, in the case of sudden or extraordinary circumstances, you know you're about to be attacked. You actually would be expected to do something, and lawfully you are allowed to.
That potentially took you outside of your own network boundary, Helaine.
Correct. Yes. So these external circumstances mean that you will commit a crime if you do certain things. Now, it is a crime to go into an area where you don't have the authorization to do so. So it's the crime of unauthorized access that will not be considered a crime if you act under these four circumstances that I'm describing.
So I was in it wasn't a hypothetical, it was an actual case study in a session in Tel Aviv a few years ago at one of the cyber conferences, and there were representatives from US, France, Germany, Australia, and we're looking at a particular incident where an Israeli hospital had been attacked. Information had been stolen. In their forensic research, they discovered the identity of the staging server that the data had been uploaded to, and they had the admin credentials to that server, and they could have the ability to go out and find out what had been stolen. And they were faced with the dilemma as whether or not they could do that. In the event, with the assistance of their police force, they did act and did recover the information. They didn't speak of what other actions they may have taken. But
And I want to respond to that because that's a really important point. And we've got a slide coming up about before, during, and after. What you've just described is a post ex facto circumstance. They know afterwards, you're almost always bound in those circumstances to go and get help from law enforcement.
yes,
Circumstances I'm talking about are all these sudden, extraordinary events that are unexpected, where you can act on your own, even sometimes preemptively, but not post ex facto.
so let's just go to that next slide before I throw to Gabby again. This is the slide you're referring to, right?
Correct.
So just talk us through this.
Well, essentially, in the first place, you need to do all of your preparatory work. What are the circumstances? What are the risks? What might happen? Run those scenarios, know when to triage, when to do this, when to cut off. All of that homework must be very clearly undertaken and documented for due diligence and due care purposes. During an event, if any of these sudden extraordinary things happen, if you believe there is an event that's going to happen, is happening, it's suddenly, if you're under distress, duress because you think or somebody's threatening you and you believe the threat will become reality, in all of those circumstances, you're almost bound to act because you can't sit on your hands and do nothing. Those are the circumstances where these issues that I'm talking about from the Criminal Code Act will
So this discretion to act
do something that won't be considered an offence.
So the discretion to act in take an act which would normally be qualified as a criminal act becomes acceptable given the circumstances that you're in imminent danger.
Correct. And broadly, it is prefaced by the fact that it must be reasonable behavior. But interestingly, it's always built on whether you believe that this is happening or about to happen. So you don't actually need, empirical proof beforehand.
So this is really interesting because this is so different from the kind of psychological process that seems to go on in these incidents that I've been associated with. Gabby, I wonder if you could come in here and talk about it from a practitioner's point of view as to how much confidence to make those kind of bold decisions that you find yourself having, or the discretion that you find yourself having as a practitioner.
Yeah, I'll say, even though I work in this space, it still makes me like a little queasy to think about where is the line drawn. And I think that's partially because, as a community, we think of cybersecurity in a very risk-adverse way.
Yes.
I also think that we have not done a lot of good job. Haven't done a good job talking about that, where that line is between what is your network, what is your role as a defender, and at what point do you cross this line? Because we haven't, other than Helaine, there's not really a lot of people talking about this. So I think, like, from a practitioner's standpoint, and to the point that we were talking about earlier, it's hard to plan for what types of responses are you going to have when you haven't really thought about it. So I'm a big fan of tabletop exercises where we throw the art of the possible in there. Say, black swan events, talk about, escaping from what we traditionally think of is our threat model, given our cyber threat intelligence for our organization. And we also like to talk about, know yourself, know your enemy, and try to step away from the biases that you have about what an adversary is targeting for your organization. MITRE, we do a lot of research and development. We tend to think adversaries are going to target our intellectual property. But in reality, adversaries love our connection to government facilities. So that's, I think thinking about what is the opportunity space for the adversary, getting in that adversary mindset is critical for being able to role play tabletop exercise out how you as a defender are going to respond in these situations. And it's hard to have good clarity, even with those exercises.
This is where the intelligence part that Marcus Thompson talks about is so relevant, that you have to have an outside-in view and an adversary perspective against of what your adversary's intentions might be. And that's not as easy, that's not that easy to come by, but that's something we have to strive for.
Absolutely.
A relevant point also, and Gabby's mentioned that, as soon as when we lost the perimeter, when we started using cloud as pervasively as we do, we lost the very clear lines of when you are entering an area where you have no authority to go. And that's really fuzzy, but everything depends on the knowledge you have of your environment or the threats that are around you. And that's where people are really not paying enough attention.
And that's where cyber deception and these decoy tools have a capacity to expose events that are otherwise can pass under the radar because of our anomaly detection not working sufficiently or working too well and providing so many potential alerts that the security operations center just drowns in the data and has to turn the volume knob down and actually potentially miss genuinely malicious events. So I think then let's move on to how we go about this. And I suppose that anybody in this session or listening to the session will know that we're arguing that organizations need to do pre-planning legal scenarios on what is lawful in what circumstances, and that will then equip you and prepare you to be able to act decisively in that golden time when you're in the green spaces here, because after the event, you're not free to act. You're that potential opportunity to act is only in the anticipation and in the heat of the moment. Is that right, Helaine?
Correct. Let me give you a couple more pointers of the requirements of each of these 4 provisions of the Criminal Code Act. So the first one is intervening conduct or event. Now, all of these 4 actually relate to external factors. So in this first case, a person is not criminally responsible for an offense. So they do something that protect themselves and they cause damage to someone else's property. This is in response to a human act or a non-human act. And clearly that's relevant in terms of any attacks against a network or an environment. And all you need to do is behave reasonably. Now, that's also what you need to thread out, what directors need to thread out. And it goes to the point I made about what is now reasonable in the circumstances, because that bar is changing. If most people are saying, I need to have greater visibility of my environment, and you fail to do that, you're going to be more likely to be in trouble from the authorities or shareholders or people with an interest. So again, directors need to know what's involved. The second one is duress, and it's simply, if somebody makes a threat. Now, in some circumstances, cyber criminals do make threats. I mean, we saw it in Medibank when attackers said they're going to publish everything. That's a threat. Yep. If you believe that the threat is likely to happen and there's not much you can do about it, you're allowed to behave differently. Again, in this case, you need to be careful because you can't behave ex post facto. But the law allows you to do something under circumstances where you're under this duress factor. The next one is suddenly and extraordinary emergency. Something has suddenly happened. You're not expecting it. There's some, malware coming in from an air conditioning in a building, and we can thread out that sample a little bit later. And if you defend yourself, for example, you might destroy that piece of property. Does it matter? Not actually, because the law says you're not liable if you behave under these circumstances in a way that's going to, otherwise be a crime, destruction of property. Yep. And then the ones on self-defense, I wanted to make a point of, because in most of these cases, the law talks about a person. The connection that we need to draw is in law, and very specifically in the Criminal Code Act, a person is also a juristic person. So it's a company. And the Criminal Code also speaks very clearly about the liability of an individual director who is really responsible for the company. So it's very tied. It's very logical, actually, if you understand the building blocks, what's involved here. And as I said, to cement my point at the beginning, these are behaviors that human societies have understood for thousands of years. We are not only entitled to, but we absolutely must defend ourselves under certain circumstances, and the law recognizes that.
So in that case, Gabby, is there room for us to run a kind of a public program of intellectual property development by actually working through publicly what these scenarios could look like and determining what is reasonable in those circumstances, so that people could have confidence to act more decisively when in the green zone, when they actually have the legal privileges to do so?
Yeah, absolutely. I think all of these planning and thought exercise opportunities are just a great way to exercise teams to have it become muscle memory instead of reacting to something that they didn't anticipate on the fly. Like anytime where you can rely on training and like the rules of engagement that we talked about earlier, it's your situation handling is going to be so much more well thought out and informed than acting off the cuff. So yes, I absolutely agree with you.
So when you're doing a wargaming or tabletop exercises like this, do you have legal people at the table also considering, okay, in this circumstances you can do this, in that circumstances you can do that? Are you bringing that into your planning?
So very infrequently, and I think that's something that we need to get better about, of thinking of cybersecurity as a multidisciplinary field. And oftentimes we have the technologists in the room, we have the operators in the room, but there are gaps to fill, like bringing in more legal people to these tabletop exercises. So yes, I will acknowledge that that is an opportunity space that I would love to seize more of.
So Helaine, I think that you're arguing, though, that it's essential that we actually bring the legal aspects into this. And if we do so, we're going to actually greatly empower our defense.
It is. One point is, I'm a great believer in the interpretive overarching legal recognition that was given through the Electronic Transaction Acts that came out of the model laws and conventions of the late 90s. People don't see that enough, but I'm really thrilled to say Microsoft is doing this. The American courts are recognizing it. They're using old laws like trespass to chattels. That is an equivalent for somebody unauthorized, in an unauthorized way, gaining access to computers. They're using intellectual property laws to say that when somebody uses phishing attacks and they're using your brands and misappropriating your valuable intellectual property, that is equivalent to all of the cyber crimes we see today. So phishing is the same as intellectual property. It's really interesting. We should be doing more of that. I'm a great proponent of, as I said, these laws are common. Self-defense is recognized all over the world. Now, in the work that was done in Talon, the experts recognized and agreed that international law applies to cyberspace. Mm-hmm. They then did Talon 2, which was about cyber operations. But what we really need to do is have a body of work that includes the application of national legal law to cyberspace, because you'll find it's the same in almost every case. And as Gabby said, it's not just lawyers, it's practitioners, it's people from risk, it's people from policy, it's people from the executive arm of government like DFAT in Australia that I really believe should be negotiating these international contracts that says, we agree that, for example, self-defense, the interpretation of what it means to remove somebody from your network in the same way as it means to remove somebody from your property. How precisely can we interpret that? Because not many people will rely on the interpretation, particularly because Australia likes this very specific law for everything. But we need to think differently. And, Microsoft is leading the way in doing this.
Gabby, you had something to contribute there.
Yeah. I did want to chime back in on my point earlier and saying, like, of course, when we are running operations, we always have someone from legal, from risk management, as well as our InfoSec team to sign off on anything before we do. But that I want to draw a distinction of that. That discussion is very different than these types of tabletop exercises to pre-plan these legal scenarios. And I think the more opportunities that we have to kind of push our idea of the art of the possible of what could happen and be experimental and kind of dream up new scenarios, I think is just really powerful.
Thank you for that. I couldn't agree more. In fact, it's fair to say that it's one of the primary objectives of the Active Cyber Defence Alliance as an association, as a group, to actually stir the pot and get a bit of angst and fire and vinegar into this whole space, so that people start to argue about it, because that's exactly what we need to have happen. At the moment, there seems to be like a blind spot, a big no-go zone that nobody wants to go to. It's sort of complex and dangerous, and they're keeping away from it. I'm having a flashback to Hitchhiker's Guide to the Galaxy and the SCP field, that somebody else's problem field that stops you seeing a flying saucer landing on the Lord's cricket ground during a test match, during an Ashes match against Australia. The point is that people just don't want to go there because there's fear, uncertainty, and doubt, and so they're just skirting around it. But we actually need to get this out in the open and argue the toss and find out where the boundaries lie, because we may find that they greatly empower us in our defence against some of the actors that are hurting us at the moment. So to make that a bit more practical, you've put forward two very brief, you've got 2-line hypotheticals of company and data at risk, and life, hospital, and data at risk. And I think, Helaine, your intention was to show how the difference, how the difference of these two scenarios applies and creates different options for what actions you can take. So would you like to take us through that?
I'm going to just plant some seeds here, and then Gabby's going to get involved in a more practical way. The provisions of law that I'm talking about require that the behavior is reasonable in the circumstances, and also that you may not kill anybody in taking a response. So about reasonableness, what most people call proportionality. So if we say you've got a company, there is an attack, data is being exfiltrated. If you say, the example I used just now, there's an air conditioning unit in the building, or there might be individual customers of an organization who have really dirty, devices. To what extent do you balance the need to protect the data from exfiltration, and can you do something that might stop the air conditioner working, or end up bricking a customer phone? Okay. I think that's the first scenario, and I think that you will find there are ways of dealing with that you might very well need to do. The other example...
You're saying that the air conditioning, it's not the air conditioning unit, it's the electronic control system that controls the air conditioning unit is being used.
It doesn't matter what it is. You're going to end up with a situation where you damage property, right, which is not allowed, right? But under these circumstances, when you've got a balance decision to make, is the protection of this property, being data or money, or something with value, more or less important than stopping an air conditioner from working or from bricking some individual's computer?
So there's an individual person whose computer has been hijacked and is being used to attack the bank, and we're saying that the bank would be within its rights in the heat of the moment to take actions to, we say, brick, basically freeze up that device so to make it unusable.
I'm saying that's what this law allows, yes.
So we're saying that is lawful in that circumstance. Yeah, well, I mean, subject to all the various caveats and advice. So in that case, before for that to be effective, you would definitely need an appropriately qualified legal advisor in the incident response team as events unfold, advising you whether or not, or what was proportionalized. Or would that be possible to delegate that to staff in certain circumstances where there was clarity of the facts?
You've got to run the circumstances firsthand. You also need to deal with, for example, customers and say, if this happens, the result might be X, Y, Z. So there are many, many aspects of dealing with these kind of conditions.
So you can forewarn your customers.
Of service. Beg your pardon?
You can forewarn your customers that if your device gets hijacked and is used to attack us, we will brick you.
Yes, Andrew, there are many ways of getting consent. Many ways of changing the unauthorized to authorized. But that's what you've got to plan ahead, and you can actually, you have almost a workflow process or a sign-off process that allows certain things to happen.
And Gabby, what have you got to say on this? How does this affect you?
Yeah, kind of the analogy that I thought about is, if an adversary has targeted a particular employee at an organization and has compromised their machine. How can the incident response team take that that laptop and say, okay, we're going to pivot this and pivot the adversary into a deception environment that we've already stood up. And that way, you know, we're encouraging the adversary to continue their operation, but in a part of our network that we've isolated. And how can we make that look enticing for the adversary to continue their operation? Because the longer that they're acting within this deception environment, the less time that they're taking to target our production organization or someone else's production network. So I think from that perspective, the pivoting of an adversary into a different part of a network, I think is a really strong place for an incident response team to both learn more about the adversary's capabilities and their targeting, as well as a protection measure for the production network of that organization.
Yeah, this is really interesting. So what you're highlighting is that there's a whole level of maturity beyond simply, oh, you know, what are we going to do? You know, we're talking it as a binary decision. Are we going to do nothing or brick my the attacking phone? But what you're saying, no, that's just reactive in a sense. This is we have to assume these things are going to happen. You are going to be breached. So when you do, this is how you get ready. You have fake environments to channel your adversaries into, and then you control them and manipulate them rather than them manipulating you. That's what I'm hearing.
Yeah, exactly. And I'll admit that that's something that definitely is more on the mature side of the spectrum for a SOC team. But I think that there's, you know, a massive amount of information that you can learn by playing into that opportunity.
I want to say that is exactly right. And that's where you want to get. What my part of this discussion is, if something goes wrong and damage is caused, you're not liable.
So Gabby, I know that in the MITRE Engage framework, you use terms such as disrupt and block or prevent. What sort of, you know, techniques are we talking about to achieve that? Are they in the realm of that Helaine is discussing, or are they, you know, what do they look like in reality?
Yeah, and I do think it depends organization to organization. What is their risk tolerance? What is good for their business and for their organization, while understanding of, like, if you have a critical asset, that the availability of that asset is of the utmost importance, particularly from a safety standpoint. It is good to have an understanding of what that risk tolerance is and the appropriate measured response for the organization.
Okay, so let's just jump to the live hospital and data. We're really almost out of time. We may go a few minutes over for those of you who can stay with us. But Helaine, talk to this slide now.
We can do this quickly, Andrew, because we're building on what we've already discussed. Let's take a sample here. If you've got a situation, and there've been exercises run even here in Australia in what they call hybrid attacks. So you take out one part of a network, one part of critical infrastructure, and it impacts down the line, often dealing or resulting in a possible loss of life. If you have, for example, something, let's say instead of a phone or a computer that is infected, you've got a self-driving car or a smart car that is used in attack, and we know that they have been hacked. And there is the possibility that they won't be able to control themselves, and they start banging into buildings, a hospital and so on. What do you do about that? Can you then do something that is going to destroy the car? What you can't do is make a decision that's going to result in somebody dying. So it's really just this sample as against the other one is just to say you can destroy property, but you can't do something that's going to destroy a life.
You can brick a phone, but you can't brick a car.
Something like that, yeah.
Yeah, you can't.
Again, these are extreme examples. What we're trying to get to is what MITRE is doing, where you manage all of this within your environment, because that removes all of the risk of this external, unauthorized, extreme behavior that is not reasonable or proportional within the circumstances, and should never result or get anywhere close to loss of life, because you will manage it before then.
So I suppose if we wanted to wrap this up with a summary, and I'll give my two bobs worth and ask you each to comment. what we're arguing for is that organizations really need to do scenario planning that consider active defense and consider what discretion they have to act during that period of anticipation of seeing an attack coming, of actually engaging an adversary in real time, and how they might use those privileges to plan a more effective cyber defense.
That's right, Andrew. The only thing I'd add to that is what this is really all about is the ability to know what's going on around you, the intelligence aspect, which is why you need the kind of devices and behaviors that we talk about in active defense.
Deception tools and the intelligence gathering tools and so forth.
Yeah, and I'll add in the throwback to the pre, during, and post compromise slide, and say, you know, draw a very clear line for hackback and say that that is outside the scope. So I think discussions like this are really fantastic. The more people you can have in the room with the diverse backgrounds and experiences to talk through what might come up is really fantastic, to have that threat-informed defense, the proactive opportunities for the defenders to anticipate and then respond.
So we had clarifying that offence is out of grounds, but there is this grey area. So we're trying to clarify what that grey area entails. We made specific statements about timing, and the truth is that most organisations and many breaches we only find out about post facto anyway. So it's not relevant in those cases. But I think we're of the view that with effective adversary engagement tools, including cyber deception and the like, we can get that awareness during and in advance of an attack and actually see the adversary coming. So we do need to start to think about what our options could be to mitigate the risk to us when those things occur. We're out of time, but if anybody in the session now would like to ask any questions, I think we have a little more time. Helaine and Gabby, can you hold on for a bit?
Mm-hmm. Yes.
I have a question for Helaine if we don't have any questions from the audience.
Yes.
Yeah. So, and this might end up evolving into something that's a much wider conversation than today, but I'm interested in what your thoughts are on, you know, when we are provisioning decoy systems with artifacts to make them look realistic, especially from like the intellectual property side, if we're generating content like Word documents, PDFs, maybe even blueprints, at what point do organizations have to be worried about what the content they're seeding in that decoy system? I'm thinking specifically, there's a something that happened in the 1980s, I think in Tobolsk, Russia, where the CIA planted blueprints that were then stolen by Russians. And when they used those blueprints, it caused a factory to blow up. So I'm really interested in your perspective on that, because I think as the field starts to get more mature, we'll have to start thinking about, you know, at what point is there a line of the type of decoy content that we can seed these systems with, and thinking of, you know, at what point are we using that as a deceptive artifact versus a booby trap?
Yes. There are a number of issues that you raised, Gabby. Firstly, there are quite a number of laws that deal with this issue of dishonesty, deceit, and so on. Most of them go to financial crimes or crimes for benefit, and they don't really have an application that I can see in this environment. As an individual professional, and I like to think thinking person, I am extremely concerned about the state of the world today and this issue of misinformation, the lack of truth. We have really let things slide beyond where we currently know what is right or wrong, truth or not truth. That needs much more engagement from society, generally speaking. And that's a big conversation I'd love to engage in. The third point I want to make now goes to the issue of you're putting, let's say, blueprints again out there, they're not correct, somebody picks them up and does something with them. It's a fascinating argument because again, I mean, look how we manage things in a commercial environment. We say, even when we're being honest, this is the best information, it's as up to date as we can get. We're not liable if you use it for other reasons. It's only, so contractually, there's a tremendous amount that we can use to argue and to look for certainty. But in addition to that, the fact that these people then pick it up and act upon it, I mean, think about it. Are they going to come to some law enforcement body and say, oh, this is not a good thing, we relied on that, and you know, now this is broken? So you get this almost a estoppel factor where somebody can't argue against something that they have believed and helped create. So there are many, many aspects to this. The fact that they break something in terms of what we've discussed in this doesn't really matter. But they would hardly be, as the malactors, they would hardly be in a position to go to the law and say, help me.
Yeah.
Morally is a different question.
These things need discussion, and that's why this is so exciting. As human beings, we need to find a new way to say what is acceptable in the way we operate online today.
You're here to that. That's a great way to finish the presentation today. As human beings, we need to find a better way to figure out what is acceptable in the cyber realm. Thank you for your contribution today, Helaine. It's been really appreciated, I'm sure, by everybody and those that will watch this. And thanks also for bringing in that practical perspective of how this is working out in the field, Gabby. I really appreciate that too.
Thank you.
Thank you both.
Well, thank you, everybody, and all the best. You'll be able to get this in a week or so from our website, the acda.group, or from our LinkedIn page, which you guess you know where it is because you found yourself to this webinar. So thanks for joining us.
Bye-bye.
Thank you.
Okay. Bye for now.